Welcome to The Callover, a Queensland Law Society podcast that hopes to inspire a future of connected, capable and healthy lawyers. We acknowledge the traditional owners of the lands on which we record this podcast, the Honourable and Yagara peoples. We pay our respects to elders past, present and emerging, and to the lawmen and lawwomen who for tens of thousands of years ensured the peace, order and good governance of this place, long before it became known as Queensland. Welcome to this episode of The Callover. I'm Georgia Athanasoulis, and today I have the immense honour and delight of welcoming the Honourable Justice Michael Kirby AC CMG back to The Callover. Michael Kirby is a man who needs no introduction. He was called to the bar in 1967 and in 1975 became the youngest man to hold a federal judicial office when he was appointed as the Deputy President of the Australian Conciliation and Arbitration Commission. In 1983, he was appointed as a judge of the Federal Court of Australia, and in 1984 became the President of the New South Wales Court of Appeal. There he served until 1996, when he was appointed as a Justice of the High Court of Australia. Apart from his judicial appointments, His Honour has also served as the Special Representative of the Secretary-General of the United Nations for Human Rights in Cambodia between 1993 and 1996, and as a member of the International Bioethics Committee of UNESCO, which in 2005 generated the Universal Declaration on Bioethics and Human Rights. In his second appearance on The Callover, we have the privilege of hearing more about his incredible career, the benefits of tackling complex issues in a multidisciplinary way or by implementing alternative dispute resolution processes, and how the development of technology has influenced the law. Michael Kirby, welcome back to The Callover.
Thank you very much. I'm looking forward to another cross-examination by you, Georgia.
I'm very grateful that you've come back to Brisbane for this episode. Last time you joined me on the podcast, you told me about the Walgett case that you were involved in as an advocate and the Wick case that came before you early on during your time on the High Court. I appreciate that you said you didn't have favourites when it came to your cases, but can you tell me about another case that you think was particularly memorable for your time on the High Court?
Well, there is a temptation in my boots to like your dissenting decisions. And it's important to say that though there were a number of dissenting decisions, in most matters there was agreement, especially if you add in the special leave applications on which the High Court of Australia was generally, in my time, and is still unanimous. But I could reel off various dissenting opinions, but one that I will mention is the Wurrajil case. This was a case that I decided in 2008, and it was handed down on the very last day of my service as a Justice of the High Court. So this was the sort of curtain call farewell. And it was a case that was challenging the Northern Territory intervention. That had been adopted by the Howard government pursuant to a royal commission by the Solicitor General of the Northern Territory, Mr. Wild, and he had pointed to the problems that were arising out of excessive consumption of alcohol and allegedly excessive availability of pornography and other abuses of the Indigenous people, First Nations people as we now call them. And the case concerned the constitutional validity of the Northern Territory intervention, because the intervention was done pursuant to a federal act which allowed the federal authorities to seize people's property, to take over the entry into their community, to stop various activities. And the question was it done in a way that was conformable to the Australian Constitution? And that was something which certainly by the very end of my service on the High Court of 13 years, I was quite accustomed to dealing with. In fact, the judges of the High Court are possibly some of the few judges and lawyers in Australia who have the Constitution by their bedside and live and sleep and dream the Australian Constitution. So the question that was raised was it constitutionally valid because the terms on which the federal authorities were doing this, which is an unusual thing to go in and seize people's property and take over their communities and boss them about, conformed to the provisions in the Constitution. One of the few provisions in the Australian Constitution which borders on a human rights constitutional provision is that provision which says that if the Commonwealth seizes property, it must provide just terms for the seizure. And the First Nations people, represented by Mr. Wurrajul, said that the Commonwealth, by its legislation, had not provided in that way. And the Commonwealth turned up with the Solicitor General in tow to say the Commonwealth had provided. And the Commonwealth was able to point to the fact that there were explicit provisions saying that if as a result of a seizure or of any other interference in property rights, an owner of the property or the person entitled to the permanent possession of the property was disadvantaged, they would be entitled to compensation. And there were detailed provisions allowing for compensation. So they said there, that is an indication of just terms under the Constitution. Now, in the 1930s, there had been a case in which that great judge, Sir Owen Dixon, Justice Dixon of the High Court, had said, it is important to note that there is a difference between the provision of the US Constitution and the provision of the Australian Constitution in respect of providing justice to people who suffer as a result of a federal intervention. But there was an important difference, and this was called to notice by Sir Owen Dixon and became, I thought, part of the doctrine of the court. And the distinction was that in the American Constitution, I think it's the Fifth Amendment, the Bill of Rights in the US Constitution, there is a provision that says that if the federal authorities seize people's property, they've got to give just compensation. Mm-hmm. But in Australia, the phrase is different and wider, as Sir Owen Dixon pointed out. It's just terms. And so the question that was raised by the arguments put to the High Court was, did the Commonwealth provide just terms in a circumstance where the Commonwealth had not consulted the First Nations people, had not discussed the way in which their lives were going to be interfered with, and that, it was suggested, was not demonstrated by simply providing for money. There was something more important, and the argument that was advanced, which I accepted, was that you had to provide proper consultation with the First Nations people. The Australian Commonwealth and the colonies before had not really consulted the First Nations people, the Indigenous people of the continent, and Mr. Wild, in his report, said whatever you do about this in this problem in the Northern Territory, you must consult the communities concerned. You must ask them for their submissions on it. And it seemed to me that that was a very important provision, given that we had done so many things, some of them beneficial, but many of them not, to the continuance of the culture of the First Nations people without any consultation. So I thought what Mr. Wild had said was very important, and the Commonwealth had not complied with it, and by not complying with it, it gave money, but it didn't give consultation. And the Commonwealth said, oh, no, there's no real difference between the two expressions, but Sir Owen Dixon tended to suggest that there was a difference. And no, giving them the money was the most important thing for them. And I pointed to what Mr. Wilde had said in his report, and said it's not just money, and if we haven't learned anything else in our dealings with the First Nations people over nearly 200 years, it is that we do not now continue just barging in and doing things allegedly for them without consulting them. And so that was the point of distinction. The other justices of the court, all of the other justices, said there was no important distinction in the case, and therefore I was left alone on the rock saying there is a distinction, and it's an important distinction, and it goes to our relationship with the First Nations people, and we should have consulted them. And basically, I suggested, I didn't spell this out, that the real reason for the Northern Territory intervention was political. It was on the brink of an election, and it was another instance where something nasty was done to a minority because it was thought to be politically attractive and would attract votes. And so that was the point of distinction. And I went out and I looked down from the High Court on level 9 where my chambers were, and there were all the journalists and so on speaking about the matter. I don't know if they got the subtlety of the issue. Chief Justice French, who had only just arrived on the court, said that some of the expressions in my reasons for judgment were gratuitous. And I didn't like that, and so I said they were not gratuitous, they were central to my reasoning. And so that was a case where the independent judges of the High Court came to different views, but that was my last hurrah. And it was on an important matter because the relationship between the First Nations people and the settlers and their descendants is a matter lying at the heart of the justice of the Australian Constitution and how its highest court interprets that Constitution. Now, that's a long answer to a short question, but it does show that we lawyers are dealing all the time with complex issues, but within the complex issue is often a point of fundamental justice. And it was my view that consultation with the First Nations people before you went in there and banned alcohol and banned money so that they got vouchers for the things they could buy at the local store, and giving them money but not consultation was not good enough.
What would constitute appropriate consultation, do you think, in that context?
Well, that was a good question, and that's an important matter that was debated. And the government's answer was, if we went through a whole process of consultation and going into the field and speaking with First Nations people, that would take forever, and that you can't have that because there is a crisis here, an emergency. We've got to deal with it quickly. And that was a reasonable argument. But if there is an obligation of consultation, as I thought there was before you seize people's property and impose on them civil restrictions that do not exist for other citizens of the country or other people living here, then you've got to devise a method of consultation. And when the Law Reform Commission, which I chaired from 1975 to 1984, when it consulted about what should be done in proposals of law reform, we did proper consultation. We went to the people. We couldn't go to everybody, but we would go and give an opportunity for people affected and their representative organisations. There are representative organisations in the case of First Nations people, the land councils, which exist in different parts of Australia and certainly in the Northern Territory, could have been consulted and opportunities given for leaders of the Indigenous community. But the answer was not to say, oh, well, it's difficult and would take time. The answer was to try, and we didn't try. We just thought, well, we'll give them some money and that will be enough. And I didn't think it was enough.
Your time on the High Court must have had many memorable moments, but can you tell me a little bit about what life on the High Court is like?
Well, I've written about this, carefully choosing my words. The first thing to say is, and I would always tell a foreign delegation of overseas judges from Indonesia or other countries, the most important thing to say is that the judges of the High Court, as other judges in Australia, are not corrupted. They are honest, they are doing their best, they are striving to reach conclusions that were in accordance with the law, and so that was an uplifting thing, to be in a court where there was nobody who was receiving a brown paper envelope with some cash in it, and nobody was getting a personal advantage. The judges are very experienced lawyers, accomplished lawyers, and respected lawyers. But when I was at law school and taught jurisprudence by that great professor, Professor Julius Stone, he taught us that judges, especially in an appellate court, and particularly on the final appellate court, are not working on automatic pilot. Their values and their approach and attitude to problems would be affected by their different philosophies of the law. And this isn't dishonest, this is simply the reality of human decision-making. Julius Stone taught us that judges have leeways for choice. That's how he expressed it, that it's not open-ended. You can't just have palm tree justice according to the whim of the judges, but that different judges will have different reflections. And we can see this in the debates about the US Supreme Court, but it's also true of all final courts in every country, and particularly in the High Court of Australia, so far as the Australian Commonwealth is concerned. So what was it like? Well, it was every day was a test. Every day was busy. Everyone worked very hard. We had meetings, endless meetings, discussing cases. And at a certain point in the meeting, I would sometimes say, there it is. There it is. That is the San Andreas fault. That is the issue that divides us. And there was no doubt that I disagreed in some matters, not all, not even a majority. But I thought that this was because I was a bit of a leftover from the earlier time of appointments to the High Court. And that's something I just had to live with. I never thought of slitting my throat or leaving the job. I was perfectly civil and courteous. I was brought up to be courteous, and I was courteous to barristers, and I was certainly courteous to my colleagues on the court. And some of them I had things in common with, but others I thought were just a bit too conservative for my perspective. Mabo is a good instance of how sometimes when you've got an area of law that has been unchanged for a time, there is a need to shake it and to change things a bit. And that I conceived to be one of my functions on the court.
Perhaps moving away from the court, you've also been in many bodies that were not entirely legal in nature, in the sense that between 1993 and 1996 you served as the special representative of the Secretary General of the United Nations for Human Rights in Cambodia. And I understand that's a multidisciplinary project, I suppose. Can you tell me a bit about the work involved?
That project was what's called part of United Nations Special Procedures. And it's been around it was when I was appointed, around for about 20 or more years. And it's set up now within the Office of the High Commissioner for Human Rights. And now, generally, the High Commissioner for Human Rights appoints a special rapporteur, either on the country or on a human rights issue. But this was before the special procedures had matured, and therefore this was a position which was chosen by the Secretary General of the United Nations. And the Secretary General at that time was Boutros Ghali. He was an Egyptian Coptic lawyer and a very talented man, and he came to a conclusion that the regime that existed after the Khmer Rouge had been overthrown in Cambodia, and it changed its name from Kampuchea to Cambodia, back to Cambodia, that regime was oppressing the human rights of the people, and that therefore a person should be appointed who would report annually to the United Nations on what was happening so far as human rights were concerned in Cambodia. And they first of all considered appointing a person who was a judge and later the president of the World Court, Judge Kirby, who was from Senegal. But he was a very big man, and he said, I can't accept an appointment going from Dakar in Senegal to Cambodia, sitting in the back of the plane, so you've got to give me first-class travel. And it wasn't entirely self-indulgent. I mean, he was a very large man, a very well-educated and distinguished international judge. But they said there's only one person in the United Nations who goes first class, and that's the Secretary General. And so he was not appointed, and then they looked to me to be appointed. And that, I think, was because Gareth Evans, who was at the time the Australian Foreign Minister, had played a part in the Paris Accord, which resulted in the final legal overthrow of the Khmer Rouge. And so the feeling in Australia and in other countries that it supported getting rid of the Khmer Rouge, who were a pretty awful regime, considered that there should be a way that the UN could be informed about what is actually going on, and are this new government any better than the previous government? It's not an unreasonable thing to do. And so in default of Kirby and Bai, they got in touch with me and asked me would I be willing to become the special representative of the Secretary General. And so I said, yes, I will do that, but it will have to be consistent with my judicial duties in the Court of Appeal of New South Wales, of which I was the president. And so that was had to be squeezed in with my judicial duties, and they were pretty heavy as the president of a Court of Appeal. And so the net result was I would go to Cambodia about 4 times a year. When I was there, the local Office of Human Rights had a full program. I would do the rounds, going into the country districts and consulting with civil society and with people who considered that they had been oppressed, consulting with the government, consulting with the Prime Minister and with the representatives of the military and so on. And then I would report first to the Human Rights Commission, as it was then called, in Geneva, and then later in the year to the Sixth Committee of the General Assembly of the United Nations. And so I would prepare my report whilst I was in Cambodia. I was told that the practice in the United Nations is the special representative never prepares his or her own report. It's prepared by the staff. And the Secretary-General might make a few little changes here, a few little changes. I said, that is not me. I am an expert writer. I'm doing this all the time, and I'm going to do it myself. And the result of that is everybody says that the reports that I prepared by everybody, I'd say everybody except the UN staff members who didn't agree with this at all, they think they are readable. Whatever other faults I have, I can write well. And I'd had lots of practice in the Court of Appeal and was going to get more practice in the High Court. But so I would report to these two venues, and I would go through the list of the good news and the bad news, because we all know in human affairs that in most cases there are some good points and there are some bad points, and you've got to be even-handed in reporting on them and suggesting ways to improve them. And so that was what I did, and it was very interesting to me to see the horror that came over their faces because I wanted to write my own reports. But just imagine if a judge in Australia had somebody else in the back room, a bureaucrat, who would write the judge's opinion, or even an associate or a staff member. You can get help and you can get suggestions and you can have criticism and improve things, but at least in countries of the common law, and at least in Australia, the judges do their own work. And so that's what I insisted on doing. And then I would have to go to the General Assembly and report to the Sixth Committee, and then I would have to go to the Human Rights Commission, as it then was, in Geneva, and report. And there was always somebody from the government of Cambodia, and they would criticise my report and I would answer the criticism. That was another thing. You know, normally, like the World Court, there was not too much spontaneity. And in my responses, because I'd been a judge for such a long time, I was used to dealing with quite difficult concepts pretty quickly, indeed immediately. And that's how our courts work, certainly our appellate courts. And so I would always answer the government immediately. And I did that also later when I was the head of the Commission of Inquiry on North Korea. That had a similar sort of structure, and I had a similar obligation. And in the presence of the whole Human Rights Council, as it had become, I would answer at once. I would say the distinguished representative of the Democratic People's Republic of Korea has made 7 points. And I would go through the 7 points. And that was also a bit astonishing. An Australian judge let loose on the system of the United Nations was something that I don't think they'd ever, it's not quite fair to say never seen before, because Justice Richard Goldstone had a post, and he was a judge of South Africa, and he had the same background and experience. But most people don't feel comfortable doing things immediately and extempore, but that's our tradition. So I gave them a big serving, and I think they're still getting over it.
Oh, that's excellent. Another example of your involvement in a multidisciplinary initiative was in 2005 when you were appointed to the International Bioethics Committee of UNESCO, a body which in 2005 generated the Universal Declaration on Bioethics and Human Rights. What was the International Bioethics Committee responsible for?
The International Bioethics Committee of UNESCO is still in operation. In fact, I received a letter out of the blue from them only 2 weeks ago asking me to make any suggestions that I had for improvement of the agenda of the committee. UNESCO, as its title suggests, is the educational, scientific and cultural organisation of the United Nations, and is, in a sense, a think tank of the United Nations for looking at big issues that are not specific to a particular country, but which concern humanity generally. And so UNESCO grew out of its constitution, which was adopted in 1945, and it says, since wars begin in the minds of men, it said in that language at that time, since wars begin in the minds of men, it is in the minds of men that we must find the protection of peace. And that beautiful language is the inspiration of UNESCO and of its committees, and they include the International Bioethics Committee. And bioethics had suddenly become quite important for two reasons, with both of which I was involved in the United Nations. One of them was the global response to HIV and AIDS. That arose at the very beginning of my involvement with UNESCO, and the other was the Human Genome Project. Because I was a sort of photographic freak at the United Nations, I took photos of everyone who was involved in those two big responses of the United Nations. The HIV/AIDS response was extremely important because lots of people were dying and there was no vaccine and there was no cure. And we had to move quickly, and the global program on AIDS, the Global Commission on AIDS of the World Health Organization, was the organ of the United Nations that responded to that. And it did so in default of a vaccine or a cure in a way that was quite original and different and effective, and it was supported by funding from additional funding, special funding from countries like Australia and New Zealand, Britain, the United States of America. And one of the sad things of recent times is that the United States administration has for the first time cut off the funding for the response to HIV. But bioethics comes in when you consider, well, what are the principles here that will protect ethically the people who have HIV and protect them, including from local laws that punish people for various acts that are relevant to sexual activity, which can lead to the spread of the HIV virus. And so that was a tricky issue, and it was controversial, and it still is. But one of the really great things that President George W. Bush, who isn't normally a hero of liberal-minded people, one of the great things he did was to set up the it's called PEPFAR, the President's Emergency Fund for spread of the HIV. And that was a wonderful step, and it was according to moral principles, ethical principles that were devoted to saving people's lives. And I pay a tribute to President Bush, and that has unfortunately come under attack and reduction, almost abolition at the moment. Now, the UNESCO International Bioethics Committee was relevant to the Human Genome Project. The Human Genome Project resulted from scientific research for which the scientists involved gained the Nobel Prize for physics and medicine. And that went to scientists who had found the Human Genome Project and found that the basic components of all animal species and living species were to be found on the genome of that species. They were limited in number, and the question was, how would that knowledge be used in the development of medicines, in the consultation with people of different abilities? How will we approach the social and legal response to the advent of the human genome, and what should be the principles that should apply? And I think out of my work as a member of the Global Commission on AIDS, I was then appointed to be a member of the UNESCO International Bioethics Committee, and that was under the umbrella of UNESCO, the minds of men and how we could develop. And we then were set to work on the International Commission, or the International Convention on Bioethics and Human Rights. And I was appointed by the IBC, the International Bioethics Committee, to be the chair of the body that drafted this document, which has very broad principles for governing how humanity will respond to this enormous and amazing discovery of scientists about the way human beings and other creatures and other life matters develop because of these genes that send the signals that result in the living matter that is so important in our planet. And so it was a very interesting project. They were very brilliant people. Many of them were Nobel Prize winners, not Nobel Prize for Peace, which Mr. Trump wants, but Nobel Prize for Physics, Medicine, and they were participating, and it was a great privilege for a lawyer to take part and help to find the words that would be useful for the Universal Declaration, including where there were differences of opinion about what those words should contain.
It's easy for lawyers to, I think, get used to engaging primarily with lawyers, but I think, as your last example demonstrates, society's broader issues are unlikely to be solved by lawyers operating in a vacuum. What do you think, in light of the experiences you've just explained, are the benefits of applying an interdisciplinary approach to issues, even if they are issues closer to home?
Well, the answer to that question is one that I discovered when I was appointed the chair of the Australian Law Reform Commission. That happened before I served in the Global Commission on AIDS, and before I was appointed to the UNESCO International Bioethics Commission, and it was something which we found in Australia. If you get a project which has legal implications and will ultimately possibly have to have a statute or guidelines or some principles, you've got to consult. You can't deal with matters out of your own little experience, which may not be broad enough. At school, I was never brilliant at mathematics. I was very competent, but it wasn't my forte. I was good at history and at English language and all the social sciences. And that's where lawyers come in. Lawyers can actually be of help to scientists because they will go on talking, but a lawyer knows that the time comes when the talking has to stop and you've got to get a product out, whether it's a reasons for judgment or in the international sphere, a draft convention. And it wasn't easy because take the International Bioethics Committee. At the time we were meeting, there was a suggestion that fetal matter, that is to say the fetus of aborted neonates, would be thrown out and destroyed, incinerated in hospitals. But the fetus, being the beginning of life forms, is multipotent. It can develop in a much more active way, and therefore the suggestion was made, we should use this material and not throw it out because it's going to be destroyed anyway, and therefore we should try to learn from the earliest phases of the development of a genome and the species of the animals concerned, how they develop and how we can use those early forms of living matter, which have evolved from the human species as it evolved over time, coming out of the great oceans and coming up to learn to stand and ultimately form all the animals and also form the plant and life and other living matter. The human genome of the human being is about 19% the same as the human genome or the genome of the banana. That's an amazing discovery. Living matter, how something happened very early in the evolution of living matter on our planet. It's very complex, but it goes back to basic building blocks, which are the genome. And therefore, there were many people on the International Bioethics Committee who didn't feel comfortable about providing for the use of the earliest multipotent genetic material for experiments. And one of the people who didn't think that that should happen was the President of the French Republic, Mr. Chirac at the time. And he was a conservative politician, but he was also Roman Catholic, and he didn't agree to any use. He didn't agree to abortion, and he didn't agree to the destruction of fetuses because he didn't think that there should be that source of matter. These were very deep and sincere beliefs. I'm not saying that they aren't without controversy and without sincere differences of opinion, which different people hold. But that was the challenge for the International Bioethics Committee. How do we, in a world with different religions and no religion in some areas, and how do we devise a declaration that will provide guidance for the world in tackling these problems? And that was the challenge which we had. And one of the provisions that was slipped into the International Declaration on Bioethics and Human Rights was a provision expressed as such as cloning of the human species. That was to be forbidden because people were very concerned about cloning Adolf Hitler. That was slipped into the International Bioethics Committee declaration as being forbidden. But if you've sat in a hearing room and heard people come and tell you of the problems they have had in securing a genetically related child, you begin to understand that the developments of science that are designed to make it possible to overcome those physical human barriers is a matter on which other people who are suffering may have a very different view to those who are looking at it as a matter of general theory. So it was a very big opportunity. And when I got that letter just 2 weeks ago asking, well, we're getting in touch with you, we're knocking on the door, what do you think we should be looking at now? I said the International Bioethics Committee should be looking at nuclear weapons because that's a life science matter, and if we don't get control of nuclear weapons and quickly, the risks exist that nuclear weapons will be used to destroy human life and other animal life on our planet. And I think they're still in a state of shock receiving that suggestion because, of course, it's a very political matter, but it also has, since wars begin in the minds of human beings, it's in the minds of human beings that we have to find the defences of peace.
That's a beautiful way of expressing it. I hadn't heard it before you quoted UNESCO earlier, so that's great. Often as lawyers, we have a tendency to jump straight into how a dispute might be resolved through traditional means of arbitration and litigation. But in discussing the issues you've just discussed, and often in other matters that are legal disputes between people and they relate to human relations, mediation is sometimes available and a good option so that parties can come to a solution on their own terms. Can you tell me about some of the successes you've had in mediation, whether they be in a legal sense or in those international bodies?
Well, my experience in mediation has been in the national and domestic legal system, and when I was so unfairly thrown out of the High Court just because I'd reached the age of 70 and I still had all my marbles, I was looking around for something useful to do, and I was invited at that time to become the president of the Australian body that looks after mediation and conciliation and arbitration, IARMA. And so I agreed to become president of that, and some judges or ex-judges had taken on arbitration and mediation, but they hadn't undergone the course that IARMA itself was offering for mere practitioners. So I thought, I can't really become the president of this body without undergoing the course. So I went along and took part in the course, and I sat there with colleagues who were 100 years younger than I was, but we all were taught the same lesson. And the basic lesson was judges sometimes fail ex-judges fail in mediation arbitration because they're used to laying down the law. That is their job for a long time. But in mediation and arbitration, the objective, especially in mediation, is to have the decision come out of the wishes and experiences and feelings, and sometimes very strong feelings, of the parties. And so I accepted that because there were many instances that were given where you couldn't find a solution without agreement of the parties, and that was difficult to get because the parties had very strong, passionate feelings about the dispute. Just think of the dispute over a will or the lack of a will, or the dispute over very sensitive family law matters, the access to a child or custody of the child, and matters of that kind cannot be solved successfully only by a judicial decision. And in fact, in a way, it's better if you can find a solution that uses the parties and gets them together and lets them speak their minds. Up there in the High Court in Canberra, when I was sitting there in my grandeur, I would often look over the rows of, generally empty, of the courtroom and see somebody up the very back of the courtrooms in the High Court, and I often wondered, I wonder if you are really understanding what's going on here. I wonder if you're even hearing what's going on here. And that isn't the way that is posited for mediations especially.
Well, I suppose often we have to prepare our clients and ourselves to walk into a mediation because it's a very different mindset perhaps to walking into a courtroom for in the midst of litigation. What can we do better to prepare ourselves and our clients to be open to that kind of discussion and to find that resolution?
You've got to face the fact that in some instances the clients so hate each other, and sometimes there are reasons for that. It may not be unreasonable in the light of the bitterness of the experience, and therefore it's difficult to get people to postulate a possibility that they will settle and dispose of the matter. We always had in our legal system a form of arbitration, and I can tell you how it was done when I was a young barrister. It was done at the doors of the court on the morning of the case when it was listed, and everyone was there. The barristers had it all in their heads, the solicitors had all the papers and all the documents, and the witnesses were all lined up. Everything was ready to go, and at that moment, in about 10 minutes, you had to explore whether it was possible to have a bit of time to settle the matter. I mean, that's how we've been dealing with problems for centuries. And certainly all my experience as a lawyer, and some judges were better at allowing the moment, but it was a very inefficient way, and it put tremendous pressure on especially disadvantaged people, which is often the litigants themselves, put pressure on lawyers as well as that. But it put terrible pressure on the plaintiff or the defendant, and often all the cards were with one side. If it's an insurance company against a little person who's a paraplegic, then that's a very unequal battle. And basically, you can help to resolve the battle by pointing out to the insurance company the risks that they run with the very large verdicts that may go in favour of the plaintiff if the plaintiff can win. And here are the reasons why the plaintiff might win, or here are the reasons why the insurance company might win. And it's not a matter of some ex-judges, when they sit in mediations, want to just do what they've done as judges because they know what should happen, they know what is likely to happen, they are very experienced, and they may reach a view this is hopeless and that the plaintiff will undoubtedly lose. But there are lots of slips twixt the cup and the lip in litigation, as we know, and therefore you need to inject realism and possibilities and explain. And you mustn't be rushed. it's got to take time. So what used to take about 10 minutes or 20 minutes, let's meet at 9:45 and see if we can settle this. Well, all I can say is I used to, when I was a young solicitor, I would be involved in that. And looking back on it, I think it was pretty shameful, really, to put such pressure on little people who thought that's the way in Australia things are disposed of. But if they go to court, they'll get a fair hearing and hopefully a fair and legal result. But the pressure that was put by that form is not fair. But the value of mediation was take some time. Don't rush it. Don't sit the parties together where they can scratch each other's eyes out, but have them sitting in different rooms and exchange what they're thinking with their permission, and then ultimately getting, hopefully, to a point that it's a matter of the money. And then you've got to explore what is so awful that a party won't accept, or what is so wrongly excessive that another party will give. And that takes time. But I think I've had experience. I can't remember any case, only one case that I've mediated which was not settled. Because I really did believe in what I was taught in my course, sitting there in the classroom with the other mediators in training. And many of these were very young solicitors or not so young, and occasionally a not so young judge listening to this new way of dealing with things. And it was basically getting down to spinning out and systematising what used to happen in the quarter of an hour before the court sat.
And hopefully producing fairer outcomes. What are the biggest changes you've witnessed during your time in the law?
I think they include the change in the criminal law that was mandated by the High Court decision in Dietrich that demands that, at least in serious criminal trials, we won't just go through a charade of a person who is not represented against the Crown with all of the funds and talent that is available to them, that in serious criminal trials everyone will have a right to counsel at trial. And that's a big change from what happened in my day at the very beginning of my time, when you would have a so-called dock brief. The prisoner would be brought from the cells, the prisoner would be sitting there, and the prisoner would be tapped on the sleeve and said, I've got Mr. McInerney who's here, and he will be your counsel and he will do it free. But he's available now, and if you want to have his assistance, I recommend that you agree and we'll make arrangements for him to speak with you. And Mr. McInerney, waiting in the wings, would then be summoned up almost always, and he'd get the dock brief, and that was it. Now, I mentioned McInerney because when I was a very young solicitor, just appointed to be a judge, I was in Shepparton doing a matter in the Arbitration Commission, and also there at the same time was Sir Murray McInerney. And he was a judge, a senior judge of the Supreme Court of Victoria. And we sat and munched our sandwich at lunch, doing our different jobs in Shepparton, Victoria. And he told me what it was like in those days. And he told me of how he had received a dock brief involving a capital charge where the prisoner, if he were convicted, would be executed. And suddenly I looked at this old man who was younger than I am now, and he was crying. He remembered the pain of doing that was making him cry, because he was thinking back on the times of his inexperience and his incapacity to have the matter dealt with fairly by an experienced barrister, but that was the way he cut his teeth. And so that was a very bad thing in our system, and it has improved with community legal centres and with legal aid, Aboriginal Legal Service and other such services, and that has been a good development. It's not perfect because it looks after the trial, but there's no certainty that you will get legal assistance on an appeal, which can often be very important for the prisoner. But that would be the biggest change in the criminal sphere. In the civil sphere, I think the biggest change that I've witnessed in the legal profession is the growth of the mega firms, the big firms, because in my day, most of the legal firms were quite small. When I graduated in law, and did pretty brilliantly, really, even if I say so, I couldn't get a job. And likewise, when I finished high school, I got what we call in New South Wales a maximum pass in what was then the leaving certificate. I got the top mark that was possible, and I was top of the state of New South Wales in 2 subjects, but I couldn't get a job because Daddy wasn't a lawyer, or Daddy didn't have legal work with the big firms. And one of the law lecturers gave me advice. He said, "You're going to the wrong place. You should look for a small firm, because a small firm will give you more experience, and especially if you're thinking of a life in litigation, you'll be up on your feet pretty quickly." And so that's what I did. And I got my articles were in a firm with 2 solicitors, and there were 4 clerks, and that was it. We were a small thing. Now when I speak to lawyers, they talk about our team, where our team is working together, and I can always rely on some members of our team. Well, we didn't have any team. We just had Mr. Kirby, the clerk. So there have been changes. Most of them have been accompanied by technology. I remember in cases of medical negligence, for example, there were secretaries who would sit there all day, copy of a letter from Dr. So-and-so and tapping away there. That was replaced by the photocopier, and now too much is photocopied and everything is photocopied. But I think mostly it's been for the good. Definitely most of the changes have been for the good. But access to justice is our downside. Access to a lawyer is our problem, and how we ensure that that can be overcome is the challenge. And of course there are now suggestions that artificial intelligence is going at least to clear out routine matters, and that remains to be seen. But it's access to justice that has been the biggest change in my lifetime, both in criminal and civil cases.
And on the access to justice point, if you had a magic wand and could fix the situation to allow everyone even better access to justice, how would you do it?
I would say you need an inquiry, and I will do the inquiry. My fees will be modest, and I will consult everyone reasonably to see what they recommend, just as we did in the Law Reform Commission, just as I did in Cambodia, just as I did for the United Nations for North Korea. They were the ways. You can't just look into your own experience, because it may not be broad enough, and it may not have the multidisciplinary talent. It may not have the technology expertise, may not have expertise in the particular area of medical or other science.
People might have different opinions about whatever matter that comes before the court or in practice. I understand that a mantra of yours is strong differences of opinion are inevitable and healthy and should neither be suppressed nor too closely disguised. Why is it important that strong differences are not suppressed or disguised?
First of all, it is important, and maybe equally important, that strong differences are resolved, because the alternative to resolving them by discussion, by mediation, by arbitration, by litigation in courtrooms, tribunal rooms or somewhere, is the power of the purse or the power of military or other people with guns or other ways of solving issues. So I'm not for just jumping on a box and insisting on a particular point of view, but you tend to bring out the issues sharply, and you bring out the issues more effectively by ensuring that they can be put before all sides and before the decision maker in the best possible way that will explain the point of view. It's by sharpening the issues of division and decision that you can help people to come at a solution, which is a human solution dealing with a human problem, and with the aid of lawyers dealing with it lawfully.
Now, I end each episode by asking one question, which is, what is one piece of advice you would give to your younger self? But given that I asked you that last time, I thought I might ask you this instead. If you could give one piece of advice to guide the next generation of lawyers throughout their career, what would it be?
Be a joiner. Be a joiner. I don't know if I said this last time.
You did.
Because it's a very important thing to me. Last week I went to the dinner of the Council for Civil Liberties in New South Wales. There is an equivalent body, the Council for Civil Liberties in Queensland, and they do good work for people who are on the receiving end of great power, and I did that as a young solicitor, and I got noticed. And that was good for what ultimately happened in my life, because I had been involved. As it happened, somehow I made a mistake, and I had 2 dinners on that night. And so I went to another dinner, which was a dinner of the Pinnacle Foundation. The Pinnacle Foundation raises money for scholarships for young LGBTIQ people. And my partner was there, my partner Johan was there. He held the fort whilst I was attending the CCL dinner. But that's typical of my life. I've been involved in a lot of bodies, and they have enlivened me to understand the sort of concerns that exist in our world that may not necessarily be made clear by the team of very talented people looking after the big end of town may not understand the problem that longs for a young solicitor working in a small firm who is trying to not only do a good professional job and work for the rule of law, but is trying to be helpful to people and to be respectful to the dignity of people. And I always tell young lawyers, or not so young, don't go joking around in the presence of clients on their day for court or for mediation, because for them this is not a big joke, and they don't understand that you're talking to the other side's lawyer. I'm not saying that we should be deceitful, but we should be respectful. Lawyers and judges must be respectful of each other, of other practitioners, but also of the client. So that for the end of this interview is the advice. I don't think I needed to be told, don't joke around, because my parents were not rich and my family didn't have a team and didn't have lawyers, and I had difficulty getting a job even though I had great results. So I think it's important for us as a profession to be kind and respectful and to other people and to try to help them. We are a helping profession.
I don't think we could end on any better note than that. So thank you, Michael Kirby, for joining me here today.
Thank you very much, Georgia, and I'll be back for another.
I look forward to it. If you enjoyed listening to this episode of The Callover, hit subscribe and please share the link with your friends. And if there's any topic you'd like to hear us discuss or person you think should appear next on The Callover, please get in touch using the contact details in the show notes.